Hi, this is Ed Sullivan and Mark Oberti with Oberti Sullivan. Mark, there have been some interesting retaliation decisions recently. Why don't you go over the two cases that are in our adjoining paper on our presentation section of our website?
Yeah, happy to, Ed. They both come from a typically conservative court of appeals, the Seventh Circuit out of Chicago. Startling, shocking cases that you might think were no-brainers, but then they turn out to be anything but. In the first one, the African-American plaintiff had a beef with her white supervisor, went out on a leave of absence for stress, told her psychiatrist that she was having homicidal thoughts toward her supervisor. The psychiatrist actually broke privilege, called the supervisor and said, "Hey, just thought you need to know your employee's over here and she said she's thinking about killing you." Well, predictably, she got fired. She sued underneath the notion that she had threatened to kill, and that's a violation of the Postal Service policy. She sued, long story short, Seventh Circuit reversed a summary judgment and said that could be retaliation because she had filed an EEOC charge right before she got fired, and the court held, well, maybe that really wasn't a true threat. And also, interestingly, said two more things. One, they said, well, you could have given her a fitness for duty test to find out if she was really a threat. And two, they said it would be troubling to think that anybody who has a delusion of thinking about killing their supervisor or fantasizes about that could be fired for it. That's really a stunning case. Second one is also from the Seventh Circuit, where a fella, Miller, he'd asked for an accommodation underneath the Americans with Disabilities Act. They didn't give him one. He was upset about it. So one day he saw the HR lady and he admitted saying to his coworker, "Right there is arch enemy number one. I've never hit a woman before, but I'd like to knock her teeth out sometimes." The company took it as a threat and fired him. Sure enough, Seventh Circuit reversed again and said a reasonable jury could find retaliation because it had happened pretty soon after he'd asked for the accommodation. It had been denied, and supposedly there was some evidence that other employees had made similar sorts of statements and hadn't been fired. So long story short, when you have employees that have engaged in protected activities like EEOC filings or requesting accommodations, and then you fire them shortly thereafter, you might really want to think carefully about that in light of these decisions.